this ruling follows. Legal requirement on forming a political collaboration. Section 8.5 of the new elections law requires 2 or more political parties wishing to form a collaboration to pass a resolution signed by an absolute majority of each of their executive members, and to submit the signed resolutions together with the terms and conditions of the proposed collaboration to the NEC. In keeping with this law, 4 political parties, namely the All Liberian Party, ALP, the Alternative National Congress, ANC, the Labour Party, LP, and the Unity Party, UP, on July 14, 2020, submitted registration documents comprising notarized resolutions and a framework agreement bearing the signatures of 4 political leaders and chairpersons to the NEC, seeking approval to collectively operate under the name Collaborating Political Parties, CPP. The CPP's framework agreement provides, among others, an 8-month rotational chairmanship among the 4 parties, a rotational secretariat among the 4 parties, an executive committee, and a National Advisory Council. After confirming that the statutory and regulatory requirements for establishing a collaboration have been satisfied, the NEC on August 14, 2020 certificated the said 4 political parties to operate under the name Collaborating Political Parties, CPP. Subsequently, the CPP fielded candidates in the 2020 special senatorial elections, in which several of its candidates won. The CPP also fielded candidates in the 4 representative by-elections held on November 16, 2021. On January 28, 2022, the NEC received a communication including a signed resolution from the ALP informing the NEC that the ALP had withdrawn from the CPP. Among other things, the ALP stated that it cannot be bound by the CPP's framework agreement filed with the NEC because it did not sign, and that same was a product of fraud. The ALP also stated that Article 17 of the Liberian Constitution gives it the right to disassociate from the CPP. On February 17, 2022, the NEC received a communication including a signed resolution from the UP informing the NEC that the UP had withdrawn from the CPP. Similarly, the UP stated that it cannot be bound by the CPP's framework agreement filed with the NEC because it did not sign, and that same was a product of fraud. The UP also stated that Article 17 of the Liberian Constitution gives it the right to disassociate from the CPP. In response to defendants' argument that they are not bound by the CPP's framework agreement filed with the NEC because same is a product of fraud, and that Article 17 of the Liberian Constitution gives defendants the right to disassociate from the CPP, complainant CPP argued that the allegation of fraud is within the province of the criminal courts, and that until said allegation is judicially proven, defendants cannot rely on mere allegation to ignore the steps for withdrawing from the CPP. The complainant also further argued that the contract clause under Article 25 of the Liberian Constitution requires that the CPP's framework agreement be respected and upheld. While the parties herein offered several claims and counterclaims, this hearing's limited purpose here is that part of the parties' agreement which concerns defendant's ability or inability to field a candidate in a public election. In doing so, this investigation notes that Article 79 of the Liberian Constitution requires each political party to file its constitution and rules with the National Elections Commission, and that the submitted constitution and rules must conform to the provisions of the Liberian Constitution. Moreover, Section 8.5 of the new elections law requires 2 or more political parties prior to being certificated to operate as an alliance or coalition to submit the terms and conditions of their governing document to the NEC. This hearing does not believe that the legal frameworks required political parties to submit their governing documents to the NEC simply to gather dust. With the exclusive authority to conduct public elections, the NEC, as the political regulatory body, is the forum of first instance when a challenge is made to the ability or qualification of a political party to field a candidate in a pending election conducted by the NEC. We now move to the CPP's withdrawal clause. Article 8.52, quote, withdrawal. A constituent party desiring to withdraw from the CPP shall first exhaust the dispute resolution mechanism stipulated in this framework document. If the constituent party which has satisfied the dispute resolution mechanism is not satisfied with the outcome, it shall file a resolution to withdraw from the CPP, signed and duly executed by 2/3 of the membership of its National Executive Committee. It being understood, however, that a party withdrawing from the alliance prior to the next presidential, legislative, and local elections shall not field candidate in its name, unquote. This investigation reading of Article 8.52 of the CPP's framework agreement is that a constituent party that exhausts the CPP's dispute resolution mechanism and withdraws from the CPP cannot thereafter field candidates in the withdrawn party's name prior to the next presidential, legislative, and local elections. This hearing notes that, in keeping with the practice and procedure here at the NEC, when a party submits a notarized instrument, such as a governing document to the NEC, the presumption here is that the same is valid and remains as such until successfully challenged in keeping with due process of law or via amendment by the parties. This position was recently reaffirmed by the Honorable Board of Commissioners in January 2022. Hence, unless the CPP's framework agreement filed with the NEC on July 14, 2020 is amended by the parties or judicially declared invalid, the NEC will have no option but to hold the parties to the terms and conditions contained in said agreement. Having said this, this investigation pauses here to state that while this matter has generated substantial public interest, it is worth noting that the Constitution governing documents of political parties are not written at the bar of the administrative forum. Hence, questions as to whether a political governing document is wise or unwise are best directed at the political parties. Moreover, questions as to whether such agreement is constitutional or unconstitutional are best reserved for the Honorable Supreme Court, which has held that when constitutional questions are properly raised before a forum of first impression, the forum must take evidence on the factual issues before it may certify the constitutional questions to the Supreme Court. Accordingly, This investigation does not herein make any determination on the constitutional issues raised by complainants and defendants, respectively. Wherefore, and in view of the foregoing, and so as to allow the opportunity for the Honorable Supreme Court to possibly consider the constitutional questions raised in this matter, the National Elections Commission is hereby prohibited from taking any further action on any endorsement form or other documents put forth by defendants herein regarding the feeding of a candidate until otherwise determined.